Welcome to week 5, our last week of Knowledge November. Today I want to talk about monitoring of employees and their use of social media a little bit more. Can an employer go on a trawl to see what somebody's been up to? The case that springs to my mind is the Leeds football case, where the contract of the manager was going to be very expensive to get out of because it was a fixed term contract. So the employer instead did a trawl of this chap's emails for the last 10 years to find that damning piece of evidence that they needed as a smoking gun to dismiss him. Now, it wasn't an unfair dismissal case that he brought, it was a wrongful dismissal case, but essentially the judges focused on what the employer did once they knew about the content rather than how old the content was, if you like. And that's translated across into some social media cases. So one that springs to mind involved an employee who worked for British Waterways who had made posts using their equipment in relation to a period of time when he was on call, referring to the fact that because he was on call he could only get half drunk that evening. They didn't know about that post for a period of 2 years, but when they did find out about it, then they sought to take action, and that was found to be reasonable. Obviously you can't delay once you do know about something. There would be a difference, however, between posts that are being made on an employer's system using their equipment, for example, and perhaps what people are doing on their own systems. The sort of privacy issues that we've already talked about will kick in. We started the month looking at the Barbalescu case and the extent to which an employer needs to draw to somebody's attention that we can monitor. So you'll remember that was the case of the Romanian chap who'd been using a work setup chat system to have inappropriate conversations with his fiancée. The Grand Chamber of the European Court of Human Rights has been quite critical of the employer for not drawing to the employee's attention by the way we can look at the sorts of things that you are writing. So I think it's very important that we include that in our social media policies. Indeed, Information Commissioner, from a data protection perspective, if you look at the Code of Practice for employment issues, it will say that an employer needs to make it clear to employees to what extent they are being monitored. So it is important that your policy does set out to people the boundaries for any monitoring that takes place. And my suggestion is that perhaps in the past we've drawn people's attention to things like email monitoring, but perhaps not enough when it comes to monitoring of social media, for example. If anyone's got any questions, please do email me, adenton@refreshinglawlimited.co.uk. Thank you very much.